So you've won in court, but the defendant won't pay your judgment. What do you do? Most people don't realize this, but winning in court and obtaining a judgment is often the easy part. Collecting the judgment is a different story. Even though it's a court order, a judgment really is just a piece of paper signed by a judge that acknowledges that one party, the judgment debtor, owes a certain amount of money to the judgment creditor. Judgment orders very rarely will say when or if the debtor will ever pay the judgment. That being said, the law provides numerous remedies to help a creditor enforce this judgment. Unfortunately, this often means more trips to court, more time, and more money. Interest accrues on Illinois judgments at 9% per year, and judgments are enforceable for up to 27 years. The most common tools to enforce a judgment are the wage garnishment, the citation to discover assets, and the real estate lien. A wage garnishment is a way for a creditor to collect the non-exempt wages of a debtor. Illinois law allows a creditor to garnish 15% of the gross wages of a debtor every pay period. There are exceptions to this. For example, the debtor has to earn a certain amount of money, and additionally, there may be multiple garnishments. For example, a child support garnishment will always trump a wage deduction. A citation to discover assets is another powerful enforcement tool. It really allows three things. Number one, it allows the discovery of assets. Number two, it creates a continuing lien on assets of the debtor. And number three, it creates a vehicle to turn those assets over to the creditor. A citation may be directed to the actual judgment debtor or any third party reasonably believed to be in possession of assets belonging to the debtor. Once served with a citation, the judgment debtor will be required to appear in court and disclose all financial information. This includes bank account information, property ownership, wages, other sources of income, tax returns, even a list of expenses being paid by the judgment debtor. If it's a third party served with a citation, such as a bank, the bank will be asked to freeze any money in the judgment debtor's account. If assets are found during the citation proceeding, the judgment creditor will likely go into court and seek what's called a turnover order. In essence, asking a judge to turn over those assets to pay the judgment. A real estate lien can be thought of as a brick or a freeze on a piece of real estate owned by the judgment debtor. If there's a lien in place, the debtor won't be able to sell or even refinance the property until the judgment's paid. Once a judgment's entered, all the creditor has to do is record a certified copy of that judgment with the recorder of deeds, and the lien will be created for any property in that county. I would recommend seeking the assistance of a collection attorney to help enforce your judgment. Although you can do all this by yourself, it's time-consuming, difficult, and there are a lot of specific details that I didn't go into depth about. I understand that very often a creditor has paid so much just to obtain the judgment that they don't want to spend any more money on legal fees. Most collection attorneys can be retained on a contingency fee basis. That means we don't get paid unless you get paid.